All right, we will start the oral arguments this morning with Rule 20. Patrick Morrissey, Attorney General of the State of West Virginia versus the Diocese of Wheeling-Charleston, docket number 19-1056. This case is before the court under a certified question, and I will let counsel know that although Justice Workman isn't present here in the courtroom today, she is participating by listening and viewing the webcast, and she will be participating in the decision and opinion in this case. So with that, counsel for the petitioner may proceed. And can I assume that's your microphone cover on there?
It is.
Okay, good. Thank you.
Good morning. Just before we get started, let you know that court, we have the plexiglass barriers, so we have removed our masks so that we're able to ask the questions to counsel. You certainly, when it's your turn to make the arguments, you may remove your mask or you may leave it on, whichever you prefer.
Thank you, Your Honors, and may it please the Court. My name is Lindsay C. on behalf of the State of West Virginia. This case this morning is about whether a religious entity can ever be liable under the Consumer Credit and Protection Act under any circumstances. Today is not about whether the diocese has in fact violated it here. The state is confident in its case and that full discovery and the end of this proceeding will ultimately vindicate its position with a liability verdict. But those factual disputes are not relevant at this point, where the court is taking up threshold legal questions with implications far beyond this particular complaint. What matters now is that the CCPA means when it says that unfair and deceptive practices in the conduct and advertising of educational and recreational services are prohibited. There's no implicit exception for schools and camps or even religious schools and camps specifically within the statute, and the First Amendment does not require creating one either. Moving first to the constitutional issues. Here, the Circuit Court applied the wrong standard and let concerns about some hypothetical remedies drive the analysis and close the door to applying the statute to an entity like the diocese under any circumstances. Now, to begin, there are two areas where the state does agree with the Circuit Court's analysis. The first is that it's right to focus on remedies in this case. This isn't the type of free exercise challenge where the substance of the prohibition is what's giving rise to the claim. Here we don't have a circumstance where the diocese is arguing that the CCPA's restrictions on false advertising and unfair practices is something it's entitled to as a matter of religious right. So that already sets us in a different position from many free exercise claims. The only issue here is it possible to enforce the statute with remedies that don't run afoul of the First Amendment? The other area where the state agrees with the Circuit Court is that there are some potential remedies that would raise constitutional questions. Equitable relief is a very broad brush, for instance. There's a lot of things that a court could order and that the state would be entitled to seek in a case against a secular entity that would raise serious First Amendment concerns here. The Attorney General's office has deep respect for the religious liberty and mission of the diocese and the other religious entities in the state, and it has a long track record of defending religious liberty in this court and in federal courts. And we said so specifically in this action. At JA 57 and 78 in the amended complaint, the state was very clear that nothing in this action should be construed in a way that would interfere with the diocese's rights to who it hires, who it selects as teachers or other employees, or in matters of faith and doctrine. And when it comes to the prayer for relief itself, even though the state asked for all appropriate equitable relief, it specifically said that that should not include any relief that intrudes in these core areas. So we're asking the court to hold us to our word here.
Counsel, do you actually have in mind a remedy and a relief that you are seeking?
Certainly, Your Honor. There are a number of remedies that would not raise constitutional issues. We can imagine a scenario where this case proceeds, Judge Bean ultimately finds the diocese violates the CCPA, that the only appropriate remedy is a declaratory judgment saying exactly that. I'm not aware of any argument that that sort of declaratory judgment would interfere with free exercise. There's also a number of others.
What you're describing is that the Attorney General Morrissey does not have a specific remedy that he is seeking. He's hoping that this court just designates that the court below could identify an appropriate remedy.
Well, Your Honor, that is and that isn't true. The state's prayer for relief tracks the prayer for relief in almost all CCPA actions where there's a request for declaratory and injunctive relief, for civil penalties, and for all appropriate equitable relief. That's very common language, so there's nothing unique about what's happening here. What is important to look at is how the lion's share of these CCPA cases work out. The Circuit Court was very concerned that there's no way to grant relief without requiring ongoing monitoring for an indefinite period of time or interference with the exact policies and procedures of the diocese. But that doesn't happen in almost every action that our office's Consumer Protection Division brings. There are some cases where an organization may have periodic compliance reports, but most cases don't require that. The most common form of relief is an order permanently enjoining the entity from violating the act going forward, but those are usually self-policing. The Attorney General's office and the court are not looking over that entity's shoulder going into the future. So there's no reason this case would be any different. The office pleaded this case the same way as the majority of cases, and we would say that the typical relief that is sought does not violate the First Amendment. Both of those sort of declaratory orders we talked about would not raise those concerns. The same is true for civil penalties, which is another common remedy. It doesn't require any kind of ongoing monitoring or dictating any particular policies. And the same could be true for some form of backward-looking restitution. So the vast majority of remedies that are available in this case and in all CCPA cases don't raise the concerns at issue here. But the Circuit Court was wrong to let the fact that there might be some remedies be what drives the analysis and close the door to any relief in this case or in any cases against other schools or camps or religious schools and camps. The reason, as we've just discussed, is that's just not true as a matter of how the facts actually work out, but it's also incorrect as a legal matter. This case came up at the motion to dismiss stage below, and there the court is obligated to let an action go forward if there's any set of facts under which the state is entitled to relief. We've just discussed at least 4 sets of facts where we're entitled to relief that's consistent with the Constitution. The Circuit Court flipped that standard on its head and said, because it could envision a set of facts where we would not be entitled to relief, the case has to stop there. That's the wrong standard. It's also not consistent with the standard that the U.S. Supreme Court applies in these cases. And even though the certified question talks about matters of the state and federal Constitution, all of the Circuit Court's analysis looks at the federal standard under the First Amendment. The U.S. Supreme Court has been very clear that these are fact-specific inquiries, and this is not an area where rigid formulas apply. As recently as July, after briefing finished in this case, the Supreme Court doubled down on the analysis from the Hosanna Tabor case that's discussed in our briefs in the most recent Our Lady of Guadalupe case. And there the court specifically rejected an argument that even though a bright-line approach would be easier for lower courts to enforce, that that's what the Constitution requires. That sort of rigid bright-line approach is what the Circuit Court is asking this court to adopt here. Because there might be some hard questions at the remedies stage, the case shouldn't proceed at all. The U.S. Supreme Court said that's the wrong way to look at this issue. So let's look a little bit more at that federal standard. The Circuit Court focused entirely on the Lemon versus Kurtzman standard, but as we explained in our brief, even though that case has not been explicitly overruled, it's been all but repudiated by the court. In the American Legion decision from 2019, the Supreme Court said that the court frequently ignores it and doesn't apply it. And the proof is in the pudding. If you look at the Circuit Court's analysis, all of the Supreme Court cases are from the 70s. There's no example of recent cases where the Supreme Court is applying Lemon, and certainly not in this context, where the question is, when does it become inappropriate to apply a neutral and generally applicable law to a religious institution? There we have 2 key insights when the court looks at these cases. The first is that there's no default that a religious entity is going to be immune from a generally applicable law. That's something the court said in Hosanna Tabor and again in Our Lady of Guadalupe this summer. And that makes sense because there are a host of laws that we all understand do apply to religious entities, at least in many circumstances. On the federal side, copyright law and OSHA applies to federal institutions with very limited exceptions. On the state side, fire safety and other health and safety concerns apply to the state. Laws about the provision of medical services or insurance fraud apply. For instance, if there was a religiously run counseling center, it wouldn't be a defense to double billing and insurance fraud that they have a religious mission. So we're very comfortable with applying these neutral laws against religious entities. Another statute is actually very similar to what the CCPA restricts, and that's this state statute about the requirements for charitable contributions. And that's in West Virginia Code 291913. What it does is it prohibits solicitations that are deceptive or misleading or that omit material about information about how the contributions are going to be used. Deception, omission, misleading, those are the same terms that we have in the CCPA. So this is not unique to say that the statute should apply in a context like this.
Counsel, if I could just ask you, going back to the Lemon test, and I know that in the cases some of the cases you've mentioned, the Supreme Court has questioned the validity of that test, the U.S. Supreme Court. Most of those times it's questioned it was being used sort of in a different manner than what we have here. It was actually to basically enjoin particular actions of a group that were expressing religious beliefs or some type of something that was declared to be religious in its nature. Here we have sort of the opposite, where we're trying to avoid the entanglement of the government in that religious expression. And so are there any of those cases that have interpreted Lemon where they've questioned its applicability in that context?
No, Your Honor. Where Lemon has been used, the two most common scenarios is in a case like in Lemon itself, when the government is actually giving funding to a religious entity. That's the classic case where Lemon used to be applied. And then the other may be when you have a religious monument on public ground. Occasionally you'd see Lemon used there. Even in those cases, the Supreme Court has not used Lemon in recent years, but it certainly does not use Lemon in this case, which is about when does a neutral and generally applicable law apply to a religious entity. We just don't have a track record of Lemon being applied there. Of course, even if this court were inclined to apply Lemon, there's no excessive entanglement because we've already discussed the many remedies that don't require any monitoring or ongoing involvement between the religious institution and either the Attorney General's office or the court. So even if the court were inclined to look at Lemon, there's simply no excessive entanglement. But the courts who have looked at this test focus on what the Supreme Court said in Hosanna Tabor and Guadalupe. The key inquiry is, does applying the statute interfere with matters of faith, doctrine, or closely linked church governance? That's the test that the court has to look at. It's a very important test, and that's why the court consistently says that anytime we have statutes that talk about who a religious entity can hire or how they make personnel decisions, that is a constitutional violation. But nothing here requires any particular policies about who's hired or training or practices. The core of this claim is that if the diocese can do whatever it wants to when it comes to particular safety practices or training or background checks, but as soon as it includes some of those things as a factual matter in its advertisements to the general public when it's selling its services, it just has to be true. If the diocese says that everyone must pass a background check, that has to be a true fact. That's what the Consumer Protection Act is about. It's not saying that the diocese has to conduct background checks or any particular training. It's saying if it chooses to use that as a basis to try to distinguish itself from the competition, that has to be accurate. And that's the same thing that we see in a number of false advertising or failure to warn cases across the state. So there's nothing unique.
Where does the Supreme Court's analysis in Oregon versus Smith fit into this case? Because it seems to me to be a little closer comparison than some of the employment cases.
Certainly, Your Honor, and we do cite the Smith decision in our case. I will note the Supreme Court has taken up a decision to revisit Smith this term, so that may be a moving target. As the law currently stands, the state would certainly win, because what Smith says is if you have a generally applicable law, that's one that doesn't target religion specifically, generally it can apply to a religious entity. So under Smith, the state would certainly win. But even if the Supreme Court were to clarify the decision, we think it would most likely move closer to what it said in Hosanna Tabor and Guadalupe. And that asks this first question: what does it mean to actually infringe on free exercise? And that turns again on these points of doctrine, faith, and church governance. So even if the court is to back away from Smith, what it would most likely do is reaffirm what it did just in July and say that's the appropriate inquiry. So under either of those approaches, applying the CCPA simply does not violate the First Amendment.
Of course, we don't even get get there, and I don't mean to shift your argument clumsily, but I will, we don't even get there if the answer to the first certified question remains unchanged.
Of course,
And that
Your
is,
Honor.
does the CCPA even apply here?
Of course, Your Honor. We began with the First Amendment because the Circuit Court said that both questions turned on that. But of course, the question is, does it even apply? And we think this is a straightforward statutory case. Here we have education and recreation are both mentioned by name in the definition section of the statute. That makes this case very different from other CCPA cases the Court's taken up. The Circuit Court and the diocese rely heavily on Copper Beach, for instance. But there were 3 factors the Court looked at there, and all of them point in the opposite direction. The first was this Court said the text didn't give any clarity because it didn't specifically talk about landlord-tenant relationships. Of course, that's not true here. The text specifically mentions education and recreation. And the definitions didn't even plausibly extend to that context because they were talking about leases, and so definitions about sales didn't work. And the definition of a consumer lease was only a lease of goods, whereas, if anything, a residential lease was a lease of services. So we had
Counsel, if your position is that the Consumer Protection Act applies to education and recreation, how do you get past 1828-6, which says no private, parochial, or church school or school operated by any other religious group or body as part of its religious ministry or other non-public school which complies with the requirements of this article shall be subject to any other provision of law relating to education except the requirements requiring fire, safety, sanitation, and immunization. So it talks about, CCPA talks about education and recreation, but it seems to me that statute exempts religious and parochial schools from the operation of that.
Your Honor, it exempts those schools from statutes that relate to education. So the question is, what does it mean to relate to education? And the state's position is it can't be that every statute that happens to apply to a school relates to education. Otherwise, a number of these statutes we've talked about also wouldn't apply to schools. That's a very broad reading that the diocese is urging, to say that anything that applies to a school relates to education. That wouldn't affect just this case. That would affect a broad number of rules that apply to schools. So the question is, how do we know what it means to relate to education? And that statute, the legislature gave us some guideposts. It talks about the purpose for the statute, and that's to protect the rights of conscience, the content of education, selection of teachers. That's the sort of thing we know from the statute in 1828-1 that the legislature was concerned about. The CCPA doesn't relate to education because it's a broadly applicable statute. It applies to schools and camps, yes, but also to hair salons, auto dealers, debt collectors, and many others. The common element for all of those is certainly not that they provide educational services, it's that they all provide goods or services for money to the general public. So that means the CCPA relates to consumer relationships. We wouldn't say it relates to any education any more than we would say that it relates to the practice of medicine because the Act applies to hospitals, or that it relates to how cars can be manufactured because it applies to auto dealers. So that's the question here. There has to be a limiting principle for that, and we think that...
But counsel, the statute, as Justice Hutchison, you go back to 1828-1, it is a very clear statement of public policy from the legislature that says it is the public policy of the state in matters of education that no human authority shall, in any case whatsoever, control or interfere with the rights or conscience or with religious liberty. So it seems to me that trumps the reference to education under the CCPA. And 2, I guess my question is it your suggestion that under CCPA unfair practices dovetails and falls within the exception under 1828-6 as relating to fire, safety, sanitation, and immunization? And that word safety, is that the word that you were suggesting is the carve-out that allows the CCPA and the unfair practices to be triggered?
Your Honor, well, we're not arguing that exception applies, and that's because the CCPA doesn't have any substantive content to any safety requirements or standards. As we discussed before, the CCPA is generally agnostic on the position of whether there are certain safety requirements.
You're not looking at any of the exceptions outlined in 1828-6 under your argument. then how do you say the CCPA controls in light of 1828-1 and the broad premise setting forth our public policy?
Because, Your Honor, that public policy is not to infringe on religious liberty. And so we have to know, what does free exercise and religious liberty mean? And that goes back to the first argument. The Supreme Court has told us an infringement on religious liberty is not any law that applies to a religious entity. That can't be the case. It infringes on religious liberty if applying the law interferes with faith or doctrine or church governance. So we know what it means to say that the policy of our state is not to infringe on religious liberty, but that can't extend to every statute that might happen to apply to a school.
Again, 1828-6 says no private, parochial, or church school shall be subject to any other provision of law.
That relates to education, and that's the key limit.
Doesn't the diocese in operating the schools, aren't they furthering religious liberties by exercising that opportunity to have a school?
Your Honor, if the CCPA, for instance, said, if you're going to have a school, you have to do background checks for everyone, or you have to do training every year, then we would say, yes, that does interfere with the way that the school operates, the way that it expresses its religious mission. But the statute doesn't say that. The statute says if a school chooses to make that part of the way that they advertise to the general public, that has to actually be true. So the diocese could violate the statute by saying we conduct these background checks, but having a pattern of not actually doing them. If that statement wasn't in the advertisements, the CCPA would say nothing about background checks at all. So if we simply don't have a statute that's trying to dictate the way that the school operates, it's not dictating any personnel decisions, any policies. What it's saying is that a religious school, like any other school, cannot omit material facts or include false information in its advertisements. And if the court were to reach that far, that would have devastating consequences. Even if the court is skeptical about the merits of the state's case under these facts, it's easy to imagine a scenario where liability is very clear. The diocese position or this interpretation of the preemption statute would say if a religious school says 80% of its graduates get into Ivy League colleges and the reality is less than half graduate high school at all, there'd be no ability to apply the statute here. That can't be what the legislature intended, and more importantly, that can't be what the protection on religious liberty allows.
What we need to do is kick this back to the legislature and say if you intend to include parochial schools or religious schools under the CCPA, you need to say that?
No, Your Honor, that would be the opposite of the approach this court has taken in most CCPA cases. There are plenty of industries, we list them in our briefs, where they are not specifically listed in the statute, and this court has found no problem finding the CCPA applies.
Yeah, but in those examples, there's no exemption statute on the books like we have here.
Well, the exemption statute, again, is about a law that relates to education. So that's the key question we have. Does this relate to education or just happen to apply to a school? But this court hasn't ever required the legislature to name an industry specifically. But even if it did, that's exactly what the legislature did. We know the legislature intended for Article 6 to apply to schools because it included education in the statute. That argument might be more difficult if the court were operating in an area of legislative silence, but it's not. We know what the legislature was thinking. It included these industries both in the examples. And I'll also note on that point, even if the court is not persuaded on that interpretation of the preemption statute, at most that would apply to schools. The state's claims would have to still go forward as applies to camps because there's no argument that would apply to the recreational side. Here we...
Also, your time is pretty much expired. If you want to be able to rebut any other arguments, I'd ask you to bring your argument.
Of course, Your Honor. Thank you. And I'll reserve the remainder for rebuttal.
Thank you.
If the court please, Chief Justice, members of the court, let me begin my remarks by saying that child sexual abuse cannot be tolerated. The church has been working through serious issues dealing with clergy abuse. Nothing I say here today diminishes those issues. There are appropriate forums for addressing those issues. They are not, however, issues addressed in the Consumer Credit Protection Act of this state. Communications concerning the Catholic Church's own policies do not and cannot trigger oversight by the Attorney General under the CCPA and the First Amendment. They do not because state law and this court's prior precedents do not support or sustain such an overly broad application of the CCPA. They cannot, as any such attempt to control, monitor, interpret, inspect, evaluate, or supervise a church's communications concerning its own policies to its own faith community are clearly prohibited by the First Amendment freedoms and would necessarily involve excessive entanglement. This case is an unprecedented misapplication of the CCPA and an extraordinary intrusion and prior restraint on free exercise. And Justice Walker, let me turn briefly to the Smith case, and I'd like to address those cases that were discussed just briefly, and then I'll return to my remarks. But the Smith case was a criminal case. And interestingly enough, in the Smith case, the court said, the principle that laws may not suppress religious belief or practice are so well understood that few violations are recorded in our opinions. So the court has not, the United States Supreme Court has not been called upon to deal with those issues because it's rarely done. I disagree vehemently with the state's characterization of the recent case of Our Lady of Guadalupe. Our Lady of Guadalupe actually broadened the standard, but what the state has done in both its initial brief, its reply brief, and in the argument here today, has encouraged the court to look at this solely in the eyes of a selection of a minister. This is not a ministerial exception case. This is a free exercise and prior restraint case. And as Guadalupe and the authorities confirmed, we can't push that down the line. Lemon, Catholic Bishop, and Surinach are all very clear on that point. Surinach is especially important on that point. One short quote from the Surinach opinion, right to the issue of prior restraint. It is not the obligation of the school to prove as a precondition for relief at this time that this precise scenario, which hardly can be called speculative, in fact, will unfold. To the contrary, in the sensitive area of First Amendment religious freedoms, the burden is upon the state to show that implementation of a regulatory scheme will not ultimately infringe upon and entangle it in the affairs of a religion to an extent which the Constitution will not countenance. In cases of this nature, a court will often be called upon to act in a predictive posture. It may not step aside and await a course of events which promises to raise serious constitutional problems. In the Guadalupe case, they talked about free exercise. Free exercise, in this case, avoids a prior restraint. And the way the state is trying to interpret the CCPA is they would have a prior restraint on our free exercise of religion, our communications with our own faithful. As the courts have held, Lemon and Catholic Bishop in Surinach, parochial schools and religious schools, whether they be Catholic or any other faith, and as the court held in Guadalupe, there are multiple faiths in this country that have religious schools. Those schools are an instrument of the propagation of the faith. They are instrumental in the development and maintenance of the faith. And in
On
what-
that point,
Yes.
let me ask you a question.
Justice Walker.
Are there any activities relating to the schools that the diocese operates that you believe, any activities relating to those schools that would fall within the purview of the CCPA? Or is your argument that the CCPA, no matter what the diocese does in operating its schools, whether it advertises as the state opined, the wrong ratio of graduates who went to college, or whatever it may be, are there any circumstances where the CCPA would apply?
We're talking here about Article 6, Justice Walker, and the court below determined that Article 6 could not be applied to religious schools. We don't take the position that we can commit a crime. We don't take the position that we can breach a promise or a contract that we create. The Circuit Court acknowledged that in its own opinion on pages 22 and 23, that a religious school or a religious entity can create an enforceable contractual obligation. And in those cases, those promises would be enforceable separate and apart from the CPA. We can't violate the law, and that's what Smith held. So we understand that. But the prior restraint here, and the real burden here is they're not enforcing a violation of the CPA. They're attempting to enforce our own policy. So the policy for protection of children and young people, that's a policy of the Catholic Church. It's not an issue under the CCPA at all. This policy applies not only to our schools, but to our faith community, to our recreational camps in which we do propagate the faith. That's the purpose of those camps, to put a religious principle involved in the day-to-day interaction of children and adults. It also deals with the other ministries. So our Safe Environment program is a comprehensive program. And as the court noted below, we have resources attributed to it. We have employees who are assigned to help us police that. It has a training process. It has reporting mechanisms. It has a zero policy. There are many facets to that policy, but it's a policy of the Catholic Church, not a credit policy. We're so far outside the field of coverage of the Consumer Credit Protection Act in enforcing the Church's own policies through a false advertisement claim that it's just incredible. So in this context, we're not even within the scope of the CCCPA. Let me talk about a couple of things on the state law issues, because I think that is important. I think there are several aspects of the state law issues that can be approached here. And I think whether we do a case law analysis applying Copper Beech or Bear Stearns, where the relationship of the parties, in this case the relationship between the church and the faithful, is not a subject for scrutiny under the Article 6 of the CCPA. The absence of a transaction, as the court noted below, there was no transaction here that triggered coverage under the CCPA. That absence of a transaction is notable, and what wasn't addressed in the state's brief or reply brief is that under Article 6, consumer has a separate definition, and it's different than the definition in Article 1. And the definition in Article 6 deals in terms of a transaction, a commercial transaction, commerce or trade. So there's a distinction here that it really needs to be a commercial transaction. We don't have a transaction here involved. And privileges, under the definition, the general definition of services in Article 1, it doesn't say that all aspects of education are covered. And without the religious connotation here and the excess of entanglement, we still have the issue of the only aspect of services that cover education are privileges with respect to. And as we noted, there is a definition in credit that uses the term privilege. So obviously it speaks to a transaction. And in this case, as the court noted below, there are no transactions here which created a consumer violation. when we look at policy, the state can't walk back from 57 of the 162 counts of the complaint deal with the church's own policy. The Attorney General isn't competent to apply and interpret policy. The Watson, Kedroff, and Serbian cases, all of which were recently reaffirmed in Our Lady of Guadalupe, they are all cited. Lemon was cited in Justice Thomas's concurring opinion. So all 4 of those cases were just recently confirmed and cited. And they differentiate. Enforcement of the church's own policies is not within the province of state or federal government. That's very clear. And here, we're talking about the state using the Consumer Credit and Protection Act, which is designed for ordinary cash and credit transactions, and to avoid excessive terms, unfair terms in agreements, loan agreements and otherwise, to enforce a church policy. And they're going to interpret when and how we comply with our own policy. It's extraordinary. And to say that they can monitor our communications with the faithful, we're so far outside the scope of the Consumer Credit and Protection Act in this case. It's an extraordinary prior restraint. It restrains religious speech in this case. So when you look at what they talk about, it's hard to fathom how that relates to a transaction involving the purchase and sale of goods. So back to your question about can we violate, we have contracts, we have other laws, we have criminal laws that would apply. But trying to police our communications with our faithful is so far outside. And in this case, how do they determine this? I can just use one quick example. I've been a volunteer municipal judge for 42 years, small town in Glendale. From my experience, we have on the website, the state of West Virginia mandates that everybody has a driver's license. They mandate that if you're going to operate a vehicle in West Virginia, you have a driver's license. Well, I know from my experience in dealing with what I call night court, there are people who drive every day through Glendale who do not have a valid driver's license. Does that make the state's requirement deceptive? No. It means that some have not followed that policy, but it doesn't make the advertisement deceptive or wrong. Here, they choose to interpret our policy using the state's mechanism to do that, and that's inappropriate. Let me just speak briefly. When I looked at the citations, they have no cases that they can show where employee conduct was a disclosure item under a Consumer Credit and Protection Act. They have no cases where church policies were scrutinized under a Consumer Credit Protection Act. They have no cases involving employer policies where employer policies were called to task in a Consumer Credit and Protection Act. Contract claims, criminal statutes, certainly. Transactions. In our case, they're seeking to enforce the church's own policy under the pretext of a Consumer Credit Protection Act statute, which simply does not apply.
What about the state's argument that what they're really looking for is a declaration that the advertisements are effectively false? And so what remedies do you see the state being able to effectively impose?
There are cases that say that if I make a commitment and I promise specific services, that's within the province of a consumer protection statute. That's not involved in this case at all. What we're talking about is how the church describes its own policy for the protection of children and young people. And the only way the state can interpret whether or not our advertising is correct in that context is to construe that policy. That's inappropriate, and they are constitutionally incompetent to make that choice and that decision. Let me speak just briefly to 3 points on the constitutional issues. What we're asking for here is that the state says that it has the authority to inspect and monitor communications by the diocese with members of the faith community to determine if they are, in the state's estimation, truthful and consistent with its policies. That inspection and monitoring is entirely subjective and subject to the state's own discretion. That policy will end when the state determines it is finished. There's no other employer held to these standards, no other religion held to these standards, no other organization that I'm aware of is held to these standards. They're going to scrutinize church records for material omissions. They're going to scrutinize church policies for material omissions. They're going to evaluate the adequacy of the church's communications of such disclosures. They're going to determine what the church can say and when they can say it. They're going to monitor and approve communications between the church and its faithful. They're going to determine when and for how long such disclosures need to be made. The interference is unconstitutional for 3 reasons. First, the First Amendment doesn't countenance such state action. The school cases are clear. Catholic schools are an integral part of the Catholic Church. They involve substantial religious activity and purpose, and that's been held in the Lemon and Catholic Bishop in Suriname. You can't assist them under Lemon, and you can't regulate them under Catholic Bishop. Second, it is settled law that secular authorities are constitutionally prohibited from interpreting and monitoring compliance by churches with their own policies and procedures. That goes all the way back to Watson, 1871. Gonzalez, and then Kedrov, and Serbian, and now Our Lady of Guadalupe. The third point is the subjective and discretionary powers claimed by the state maximize interference in church affairs. This was a principal evil noted by the Supreme Court in the Cantwell case in the very page cited by the Attorney General in its brief. It would work a prior restraint and a chilling effect on the relations between the church and parishioners, which itself infringes the First Amendment of speech, association, and religion.